and due to the due for the sake of due process, and I think
Sorry,
that's kind of what he.
that's a word salad. It's not making any soup.
Shoulders, I am aware that I do have constitutional rights, not just the ones that were mentioned here before, and also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used. And I, the man speaking with a voice and a sound
So I'm going to
mind.
cut this off. What is a preliminary exam?
Well, before I address that, may I address
No,
a few?
sir. No, we're gonna focus our answer.
This sovereign citizen just found out the hard way why representing yourself in court is almost always a disaster. Picture this: a grown adult standing before a judge, insisting that the charges don't apply to him because, supposedly, he isn't the name on the paperwork. He's just shoulders. Yes, literally shoulders. You read that right. I honestly can't wrap my head around how anyone could genuinely believe that this qualifies as a legal argument. The courtroom instantly froze, the judge looking utterly baffled as if trying to process a foreign language. Meanwhile, the attorney defending him threw up their hands halfway through, clearly exhausted by the nonsense being spouted. It was like watching a live reenactment of the most absurd legal theories you've ever heard, all crammed into one chaotic room. I have to wonder, do sovereign citizens all get their ideas from the same conspiracy forum, or is there some underground social media group handing out scripts for courtroom theatrics? Either way, the scene was equal parts hilarious and painful to watch, and it quickly became obvious that this individual had absolutely no grasp of the law or reality. By the end of it, everyone in the courtroom, from the judge to the spectators, was left shaking their heads in disbelief. This one isn't just a funny story. It's a masterclass in why having a qualified lawyer matters, because no amount of creative thinking can replace actual legal knowledge. So buckle up and watch as this sovereign citizen spectacularly undermines his own case, turning what should have been a routine court appearance into a spectacle of epic absurdity.
I am shoulders in here by way of executive office for Lee State Thornton nonprofit organization.
Except that is Mr. Thornton announcing his appearance before the court. We are here this morning for a pre-exam conference. Mr. Anid, it is my understanding that Mr. Thornton has declined representation. However, Mr. Thornton, at every appearance, I need to remind you that you have a constitutional right to be represented by an attorney, and that if you can't afford an attorney, the court will provide one for you. I am particularly proud of the superb public defenders we have in this court. However, you may also retain any attorney you wish. You will get to choose the attorney. You would have to pay them. You have a constitutional right to represent yourself, but I have to warn you that if you proceed representing yourself, you would be held to the same standard as all attorneys who have gone to law school, passed the bar, and been admitted to practice. So the court really can't give you any breaks or help you at all. Is it your wish to represent yourself, sir?
Mr. Thornton is aware of the courtroom decorum and the standards and procedures that must be upheld by a person in representation of a party. And as again, shoulders, I am aware that I do have constitutional rights, not just the ones that were mentioned here before, and also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used, and to uphold the proper standards. Mr. Thornton does not wish to get public counsel representation as I am a legal representation by special appearance through the executive office for Mr. Thornton, and not the actual entity, Latavia State Thornton. Once again, on the record, it has not been declined that Latavia State Thornton is a nonprofit organization, which, yes, Your Honor, is a person, in fact. And I, the man speaking with a voice and a sound mind.
I'm going to cut this off. I don't want to mute you, but we have to move forward. We have an attorney standing by. That would be Mr. Foreman. Have you had an opportunity to speak with Mr. Thornton about any plea offer?
No, Your Honor, and I don't think I'll have any meaningful conversations with him based on what I see. Um, I believe that it's not clear whether what he's doing is intentional or whether this may be a competency issue. But I'm prepared to proceed. I just don't know if we should be. We should. I have a concern for his competency, to be honest with you. If the court we had the same issue all this time.
No, Mr. Thornton, one person at a time, and right now Mr. Annette is speaking.
I mean, I guess I would inquire with whether he knows what a preliminary exam is, and if he understands, if we forward, if he's gonna know what to do. I mean, I believe I have to look at the court rules. I've never dealt with this issue, but I think having standby counsel would be something that would be needed to advise him. I'll look into all that, but I just don't know if he's gonna know what a preliminary exam is. I believe this may just be a competency issue. I don't know, Your Honor.
Okay, so actually that's a good question. So Mr. Thornton, I'm going to ask you, what is a preliminary exam?
Well, before I address that, may I address
No,
it to
sir. No, we're gonna focus our answers here. What is a preliminary exam?
Your Honor.
I'm going to give you one chance to answer. What is a preliminary exam?
Court proceeding.
Okay, and what happens?
I can't be the only one getting serious deja vu of a teacher calling on a student who clearly didn't do their homework, right? Because that is exactly what watching this sovereign citizen feel like in court: pure panic and confusion. The judge calmly asked him a simple question about what a preliminary exam actually is, and this guy responded with the longest, most awkward stammer imaginable, like dial-up internet trying to connect back in the 90s. You could feel the tension in the courtroom, and if this were on Zoom, I swear every single person on the call, including his own attorney, was biting their tongue to keep from bursting out laughing. It was the ultimate I didn't study, but I'll try to bluff my way through it energy, the same kind of energy you get when you once tried to fake a book report on Moby Dick using only the back cover and your imagination. Even people with zero legal knowledge understand that a preliminary exam isn't some stage for improvising your own version of law or challenging fundamental science. It's literally just the court checking if there's enough evidence to move forward with a full trial. Yet here he was, spinning nonsense and looking more confused with each passing second, turning what should have been a straightforward question into a surreal comedy sketch. You could practically hear the collective groan and suppressed giggle of everyone present as he attempted to pull together an answer that made absolutely no sense. It's one of those moments where reality and absurdity collide, and you just can't look away, because the train wreck is both mesmerizing and painfully hilarious. So strap in, because this is about to get even more ridiculous as he tries to explain the unexplainable, and the courtroom braces itself for a full-on comedy of errors that no one involved will ever forget.
Evidence, cross-examine each other and determine whether evidence is admissible to go into continual proceedings, whether the court has jurisdictions. A plethora of matters may be brought up in a preliminary examination to see if the court has a valid standing, to see if there's anything, to see what may be addressed that's necessary as far as the parties that are at hand, not only to go about things in a one specific fashion.
Well, that's pretty. That's a pretty good answer. However, at this point, given a review of
Your Honor,
history, the court is going to sua sponte suggest that a competency exam be ordered. Mr. Anid, any response?
I agree.
Okay, thank you. Mr. Thornton, any response?
Mr. Thornton does not believe that a competency exam sua sponte is necessary and objects that as a preliminary exam is something that we can proceed to and we can address the matters and the situations that are necessary at that time, and for the sake of due process and the judicial precedence of due process, that a competency test may delay that, and it could hinder not only Mr. Thornton, but the things that Mr. Thornton does as far as the community in his career, in his family, in his life and rights, and other people that may be affected by this matter, as well as the public. Because for the judicial precedence is that Mr. Thornton is innocent and not guilty.
So, Mr. Anid, are you going to prepare a proposed order, or?
Your Honor, I think it's been a while since I've done. I believe if I'm not mistaken, it's the. I can if you want. Yes, I'll prepare an order.
All right. So, at this time, Mr. Anid, comment on the preliminary exam.
Nope. I just say we just make the preliminary examination to be determined date. If anything, reset it for another PCC or a review hearing for when we do come back with a competency opinion.
Okay. So, Mr. Thornton, you have two rights at play here. One is the preliminary exam that we just discussed, and the second is the right to have that within 21 days. So, the reason that you have a right to have that within 21 days is to prevent cases from dragging on endlessly. There are certain timelines that have to be met. However, the court can waive that 21 days if it finds good cause. And that would be, for instance, if one side had recently received discovery and was unable to proceed. Another good cause could be if someone was ill or hospitalized. There could be any number of good reasons. So I'm going to ask you, actually, Mr. Thornton, have you received any discovery in this matter?
I have not. Mr. Thornton has not received any instrument.
Okay, so, all right, two things then. First, I find good cause to waive the 21-day rule, and we will get a date. No, sir, just a minute, let me finish. You don't, no, listen, I don't want to mute you, but I have to get through this. So, you have to have, you have a constitutional right to have knowledge about your case. And if you haven't received any discovery, we can't go forward until you receive it. So two things. First, I'm going to waive the 21-day rule. And just a minute, Mr. Sid. I'm going to waive the 21-day rule, and we're going to set a date out in about a month. That'd be a placeholder date. At this point, because you are representing yourself, I'm going to allow you to converse with Mr. Anid, recognizing that you do not have discovery materials, so I do not expect this court to accept a plea bargain today.
I have this gut feeling that nothing good is about to come out of this, and honestly, I've seen enough sovereign citizen meltdowns to predict the exact pattern. Every single time one of these individuals ends up in a breakout room with a lawyer, it's like trying to teach a cat how to do algebra. Completely pointless, frustrating, and usually ending in someone storming out in anger. Now, don't get me wrong, this guy isn't the absolute worst sovereign citizen we've ever showcased on the channel. But that's like saying a wet sponge is the driest one in the sink. It doesn't make it any less useless. You can bet the attorney went in ready to actually help, only to come out questioning every career and life choice that led them to sit through this chaos. I've personally had experiences helping people with tasks that seem simple, only to find they reject reality entirely, like a coworker who refused to acknowledge the concept of jobs while I tried to help with a resume. This is exactly the same kind of energy. 2 seconds of listening, constant interruptions, and a bizarre belief that they somehow won the argument. And the routine is always the same, nonsense piled on top of nonsense, all delivered with maximum confidence and zero understanding. It's almost impressive in a way, like watching someone juggle flaming torches blindfolded, except instead of applause, everyone's left cringing. I can only imagine the attorney sitting there, slowly realizing that reason and logic aren't going to make an appearance today, while silently praying for the Zoom call to end. Let's jump back in and watch what comes next, because whatever reaction follows is bound to be equal parts exasperation, disbelief, and borderline existential questioning of one's life decision.
Okay, sound is back on at the jail, so we will go back on the record in the matter of People versus Latavius Rashad Thornton. This is case 25-0203-FY. Mr. Anid, prosecutor, and Mr. Thornton, representing himself, have met in a breakout room. So first, because the prosecutor has burden of proof, I'm going to ask Mr. Anid first, then Mr. Thornton, I'll ask you. So Mr. Anid, anything from the breakout room that you'd like to report?
Yes, I just want to make sure Mr. Thornton is there because I don't see him on here.
Oh, I see him.
Okay. Can you hear me? Okay. Yep. So we discussed. Yep. We discussed a little bit of as much as we could. I believe based on my discussions with him, I don't believe this is a competency issue. I believe this is more of the what Mr. Thorne kind of described earlier. So the plan, I think we both agreed on, is we're asking for another probable cause conference. I'm gonna somehow figure out how to provide him discovery, the complaint, the information, all the charging documents that we have. We're gonna come back. In the meantime, I'm gonna do my due diligence to speak with our office to see how we're gonna go forward with this. Because I know it's my understanding he wants to represent himself. That is his right. I believe based on the questions that you asked earlier, he answered them pretty fairly, Your Honor. I just want to make sure we got all ducks in order. I discussed a misdemeanor offer potentially with them, but also discussed that I encourage him to get a public defender. All these things I think we're going to discuss at the next probable cause conference. I think these are all appropriate matters so I can get my ducks in order. He can have discovery to know what he's looking at. And I believe at the next hearing, we will have a good understanding of what we're doing going forward.
Mr. Thornton, is that an accurate report?
It's pretty accurate, Your Honor. Just a few more points that we had discussed in that breakout room was also that it was in the discovery we would like to get subject matter in the appointment of the authorities that has been filed onto the record for these proceedings and how we came about to be into the court's jurisdiction for this matter in such fashion. And I think that's kind of
that's a word salad. It's not making any soup. Can you make sense at all? Can you rephrase that for me, Mr. Thornton?
Yeah. So just pretty much all in the discovery, we didn't want any documents that have been filed onto the case to be missing, and that's what I mean by not limited to the documents titles that he named. It include an inclusion of all documents filed with all titles under them.
Okay.
I'll chime in
Mr. Ned.
And I think kind of what he may be talking about is, and I could be wrong, is the charging documents, what gives us the authority to proceed forward and how we're proceeding forward. And I explained you should wait until you discover it because I believe that's going to be the complaint, the information, and the other charging documents to see where we're at. I could be wrong, but once he receives those, we'll come back. We'll have all the ducks in order. I think that's a good resolution we both agreed on. And in the meantime, I'll do my due diligence to speak with our office to how we're going to go forward. I told Mr. Thorne, I'm the prosecutor, understands.
One thing that always amazes me about these sovereign citizens is their commitment to contradiction. They claim they want their cases resolved quickly, yet the moment they're in court, they start arguing like they have all the time in the world and somehow earned a law degree from Google University. It's like someone saying they're starving but then spending 20 minutes ranting about how unfair the menu is, completely defeating the purpose. This guy, for instance, could have wrapped up his case in days if he had simply answered straightforward questions like a normal person, instead of launching into a long-winded speech about natural law, invisible rulebooks, or whatever else he thinks gives him a get-out-of-court-free card. They expect the system to bend entirely to their will, yet refuse to follow even the most basic rules, like refusing to pay rent in Monopoly because the Constitution supposedly doesn't mention boardwalk. And let's be honest, if there were awards for wasting court time, this man would already be standing on the podium, gold medal in hand, grinning at his own absurdity. Every moment in the courtroom feels stretched into a masterclass of delay tactics, leaving the judge, attorney, and everyone watching simultaneously exasperated and baffled. Let's dive back in and see just how many more twists, rants, and self-inflicted obstacles he can throw into the next 5 minutes, because at this point, I'm genuinely curious how far the I don't consent defense can possibly go before reality intervenes.
Not at this time, Your Honor.
Just new dates, Your Honor. New dates. New probable cause.
Okay, so we had the dates, and that is 8:30 a.m., April 25th, for a probable cause conference, and 9 a.m., May 1st, for a preliminary exam.
Okay, so the next probable cause conference is about a month away. Does that sound right?
Yes.
Okay. All right.
So, Mr. Thornton, if at any time you change your mind, you can communicate with the court and or Mr. Anid about requesting counsel. At every hearing, I'm obligated to tell you your right about counsel, and to determine determine the parameters of that. All right, so we will see you back at 8:30 a.m. April 25th. That is all.
Thank you, Your Honor.
So here we are at his final hearing for the time being, and he's at a crossroads. Either he takes the plea deal and moves on, or he decides to launch into full YouTube law school mode and represent himself, which honestly reads like the plot of the worst courtroom reality show you could imagine. Watching him is a guaranteed brain drain, faster than endlessly scrolling TikTok at 3 a.m., and somehow, the patience of the judge has been nothing short of miraculous. She sat there calmly, walking him through basic legal procedures like a mom explaining Wi-Fi to her 80-year-old dad, while he stumbled and argued like he was auditioning for a comedy sketch. Sure, some viewers might call her soft, but anyone who has faced these kinds of sovereign citizens knows that even infinite patience only stretches so far before reality starts to bend. Compared to this man, I've met Karens at retail return counters with less entitlement, and that's really saying something about his attitude. It makes you wonder if courts should even let people like this represent themselves, or if they should just hand them a coloring book, send them to a corner, and call it a day. Either way, this story is a perfect reminder that real-life legal chaos can often be stranger and far more ridiculous than anything scripted. And if you've enjoyed following this saga, don't forget to hit like and subscribe, because content like this comes around daily, and trust me, it only gets wilder from here.